Hey, welcome to our video. This is John Watts. I'm a lawyer in Alabama, and this is a case decision involving the tax court. And so this will have interest to you if you are dealing with the IRS on back taxes. Maybe you're looking at doing an installment agreement, an offer in compromise. Maybe you've received a notice of intent to levy or a federal tax lien. And right now, as I'm recording this on April 15, almost all of the collection activity of the IRS is shut down till about July 15. Now, it's not complete, but as a practical matter, for most people, that's true. But if you're in a situation where you know that you have unpaid taxes or maybe even unfiled tax returns, this is a great time to get yourself educated to understand your options and your rights. In this opinion from 2018, it gets a little technical on some things, but I think there's some lessons for us to learn from this. And again, it'll touch on installment agreement, offer and compromise, even what's called an exceptional circumstance where the IRS is allowed to just forgive the debt even though you have the ability to pay. We'll talk about collection due process, appeals, so all sorts of interesting things in this. And it's one of the few times that you'll find the tax court actually siding with the taxpayer. So we'll go to the actual opinion here. So the way we have this sort of organized is the IRS's position, the commissioner or the appeals officer, that will be in green, the taxpayer, the Lovelands, husband and wife. They'll be in purple, and then when the court's speaking, it'll be in yellow. So the commissioner has moved for summary judgment, and they say, look, I get summary judgment because the taxpayers did not submit the necessary information, financial information, during their appeal so that we could consider a proposed installment agreement. So an installment agreement is where you pay some or all of your taxes over a period of time. An offer in compromise is where you pay a reduced amount, typically all at once or over about 6 months. And so anyway, this is what an installment agreement. Here's what the taxpayers say. They go, we did give you the necessary information, but you did not consider the issues we raised in our CDP, that's collection due process hearing. And that includes an offer in compromise, an installment agreement, and an economic hardship. And the court says, we find the commissioner abused his discretion when he failed to consider the offer in compromise, proposed installment agreement, and the claim of economic hardship. So here are the facts. So during the last recession, so we're in one now, but the last one back in 2008, they lost their home. The husband became disabled. The wife survived breast cancer, and so they stopped paying their taxes. So we have these years, 11, 12, 13, 14. It's over $60,000. So in 2015, Commissioner issued a notice of intent to levy. So a notice of intent to levy is saying, we are going to seize your wages or your bank accounts, typically what we're talking about here. Now, that prompted, as it often does, the taxpayer to either reach out to a tax resolution specialist, that could be a lawyer, a CPA, an enrolled agent, or to do it on their own. And so they enter into negotiations and they made an offer in compromise. Now, when you do an offer in compromise, you have to fill out what's called a Form 433A. And this will have all sorts of financial information that you put in there and that you attach to it. And they also said, look, we have these health problems, we have the foreclosure, we have these special, unusual circumstances that limit our ability to pay. So what did the collection officer do? She rejected the offer in compromise. She said, no, you can pay the full amount, and the special circumstances are not enough to make me want to accept your offer in compromise. So they appealed that decision, which they have the right to do. And they wanted an installment agreement, but they were told, look, you've got to choose. We're not going to consider your installment agreement if you have a pending appeal. And so they withdrew their appeal because they wanted to continue to talk with the collection officer about the installment agreement. So they agreed to make voluntary payments $800 a month. They believe that was an accepted installment agreement. Now, it actually wasn't, but that's what they believe. They made a couple payments. While they're doing that, they're working to borrow money because they do have some property. And so they plan to use the proceeds from the loan to make an $11,500 payment to bring their tax liability below 50. So if you remember up here, it says it's about $60,000. Well, if you can get the amount that you owe under most circumstances, if you can get it under 50, then you can do what's called a streamlined installment agreement. And so it's easier to do that. But if you're at $50,001, you don't qualify for that. You need it under $50,000. So they submitted a loan application in 2016. This is to work out, get a loan that would pay off their mortgage or else get an additional mortgage and then use that to lower the amount of taxes. So just to kind of remember our dates here, 2015, we have that notice of intent to levy. That prompts some negotiations, offering compromise, talking about an installment agreement. And here we are, October 2016. But unfortunately, same day, Commissioner filed notice of federal tax lien on the property, and that meant they could not get their loan. Now, it's not an automatic thing that you can't get a loan if there's a tax lien. You just have to work with the IRS on it. And let me say this about tax liens. Often people think, well, there is no tax lien until there is a notice of federal tax lien filed. That's not true. The IRS says you owe money, you don't pay in 10 days, boom, a tax lien arises. Now, nobody really knows about it, okay? So you could go borrow money and that mortgage company that's loaning you money, they would be in front of the tax lien because, again, nobody knows about it. But once the tax lien is filed, now they're in line, so nobody can come behind them. So the commissioner issued notice of federal tax lien. The Lovelands timely requested an appeal, and they said, please release that lien. And, part of the reason is this is messing up our ability to get a loan. So there was a hearing set March 2nd, 2017, and they were told you need to submit the 433A. Remember, that's the offer in compromise type statement here. And so they sent a letter saying, take a look at our offer in compromise. And here's the completed form 433A. And here's our earlier letter. And we want you to look at this installment agreement. And then he also says, look, economic hardship. Okay? And called to the commissioner's attention his health problems, specifically asked what would be classified as exceptional circumstances. So the appeals officer declined to review the offer in compromise and said it wasn't properly appealed. And you've not submitted necessary financial information for the proposed partial pay installment agreement. So the appeals officer is saying, I'm not even going to look at it. Okay. But then she did say, if you will pay 84 months at $853 a month, you'll get rid of your tax liability. Well, they say we can't do that. So we got this March 2nd, appeals officer conducted a hearing, explained the hearing process, and asked, did you appeal the rejection of your offer in compromise? And the taxpayer says no, because I hope to work out an installment agreement and I want that lien removed so I can get the refinancing. So the appeals officer rejected that $800 per month partial pay and no evidence in the administrative record. The administrative record is when you go up on appeal, the documents from what you've done previously will go up to the appellate court. So it's not like when we are suing in federal court and we go take somebody's deposition or this or that. Here, it's more of whatever's been done below, and then there's a few things you can add on appeal. And so April 11, notice of determination informing them of the commissioner's determination, their right to appeal to tax court. And this points out that they requested withdrawal of the lien, and the appeals officer did not consider because they did not provide any financial information. Neither the notice nor the case history notes discussed his medical condition, disability, and how that impacts ability to pay. So, May 11, the Lovelands filed a petition for redetermination of the decision to sustain the lien. And they said, look, we disagree with what you did before, IRS, because you're causing us an economic hardship. And then we move forward to, that was in May. Now we're in tax court, and the commissioner filed a motion for summary judgment saying the taxpayers had not submitted the requested paperwork, financial information. It was not an abuse of discretion to refuse to consider the offer in compromise or to refuse withdrawal of the lien. And the commissioner says, I'm going to get an affidavit or a declaration of the appeals officer. Now, this is a little strange, and we see this in different contexts, okay? But just sort of think through the strategic purpose here. Maybe it's just coincidence, but the commissioner is saying, here's my motion for summary judgment saying we don't need a trial. This case is over. And we're going to submit our proof later. Well, really, as the person responding to that summary judgment, I don't care if you're in state court, federal court, tax court, wherever you are, you really should not have to respond until you see the evidence that the moving party here, the IRS commissioner, has made. But the court ordered them to respond. And so they submitted a response. And they said, we did submit the financial information, the substantiating documents, and the lien that caused the hardship. And then after they filed their response, then the commissioner submits that declaration. And so the court said, well, wait a minute, we've got to give the taxpayers an opportunity to respond, which is only fair. So it shows you, in tax court, they are concerned about fairness. So taxpayers again argue, provide financial information. Here's the documents they submitted. Here's copies. So a really important lesson here is, I don't care if you're dealing with your mortgage company, you're in a lawsuit, you're in tax court, you need to keep copies of what you've submitted. So if you submit, trying to get a loan modification with your mortgage company, and they say, give us all these documents, and you do it, and then they come back and say, you never gave them to us. Well, you want to be able to say, well, here's the exact copy. Okay, you don't want to be saying, well, I sent you the only copy I have, and I have no proof. So these people, they kept copies, and they had proof, which was great. So here's kind of the overall question, and then it'll get a little technical. So the question is the commissioner entitled to summary judgment? They say we've got to answer three questions. First, did the commissioner abuse his discretion in not considering that offer in compromise? Second, did he abuse his discretion in failing to consider the financial documents submitted with the Form 433A when looking at the proposed installment agreement? And then third, did he abuse his discretion when he failed to consider their special circumstances and claim of economic hardship? And this is all part of an offer in compromise. So let me just take a step back, and we have a video on this you might want to look at. Offer in compromise, it in sort of normal terms, we say that's a settlement. Okay, you're just settling with somebody that claims you owe them money. Now, it can be because liability is doubtful. In other words, do you really owe the taxes? Are we arguing over what this IRS code or regulation means? Well, it might be that the IRS says, okay, we don't want to fight that. We'll settle with you. More commonly, it's doubt as to collectability. In other words, I think I can show you, IRS, that I don't have enough money, enough assets, enough income to be able to pay this. So you should take what you can get. And then the third one, which is very unusual, is what's called this effective tax administration. And these are special circumstances. This is where sort of the classic example is, say a guy's living in a house. He's 90 years old. House is worth 100 grand. He has a lot of disabilities. The house is set up for his disabilities. And technically he could sell that house and pay off his debt, but he'd have nowhere to live because he couldn't, fix a house up the same way. Well, then they might go, well, you have the ability to pay, which is always what the IRS is looking for. But in these exceptional circumstances, we'll pass on that. Okay. And so the three questions are, hey, IRS, did you mess up by not considering the offer in compromise, or number two, not considering the Form 433A when looking at that installment agreement? And how about these special circumstances? So the court will tell us what summary judgment is. Now, in federal court and most state courts, this is called Rule 56. Same basic principle, just used as a different number in tax court. So same thing in bankruptcy court. We have bankruptcy lawyers that will bring us in to litigate cases in bankruptcy court. Well, they use different numbers, but court is pretty much the same all over. I've been in court at, Manhattan, New York City. I've been, other states, Alabama. I mean, all different varieties. Arbitration, probate courts in other states. Sort of odd story there, but point is, most court is similar, all right? And this is true of summary judgment. So look, the purpose of summary judgment: expedite litigation, avoid unnecessary and expensive trials. The question is, are there genuine disputes on material facts? If there are, then normally summary judgment's not appropriate. We have to resolve those factual controversies. So sort of the classic, think of a car wreck. You and I are suing each other. I say I had the green light. You say you had the green light. Well, the judge can't really decide. That's got to go to the jury, because the jury's going to decide either you had the green light and you win, or I had the green light and I win. The judge is not supposed to make that decision. So then the court says we need to consider the factual materials, inferences drawn from them in light most favorable to the non-moving party. So here's what that means. Again, same in every other type of court. Whoever's moving for summary judgment, there may be inferences, there may be factual issues where we go, wow, that could go either way. Well, the judge is supposed to rule in favor of the non-moving party, okay, and say, if it's not absolutely clear, then let's go forward with the trial. So the non-moving party here is the taxpayer. And so non-moving party may not rest on mere allegations or denials, but set forth specific facts. So if the non-moving party actually does their job right, then I'm sorry, I may have said that wrong. If the moving party, here the IRS, does its job right, then the taxpayer, as a non-moving party, has got to respond with factual evidence, not merely saying, well, I disagree. They have to actually have evidence. So we have the CDP hearing, collection due process hearing. Very important concept when you're dealing with the IRS. Taxpayer may raise any issue that is relevant to an unpaid tax, a notice, federal tax lien, proposed levy, including challenges to the appropriateness of the collection action and offers of collection alternative. That's going to be the primary thing, where these are collection alternatives. Okay? So almost all tax resolution work is not where we're fighting over, was that a proper deduction and that type of thing. It's, okay, look, I owe $100,000 to the IRS, but let me propose this alternative where I pay $50,000 or $5,000, or I do this installment agreement or whatever it might be. That's what we're primarily talking about, not so much liability. So when the underlying liability is not at issue, liability meaning do you actually owe the tax? And almost always this is true. When the liability is not at issue, we review the commissioner's collection determination for abuse of discretion. So we do not conduct an independent review. We don't substitute our own judgment for the commissioner. Instead, we only ensure the commissioner's decision was not arbitrary, capricious, or without sound basis. So again, it's a very similar standard if we're talking about long-term disability payments under a federal law called ERISA. If we're talking about, we've sued companies for kind of messing with the profit-sharing program, and that falls under ERISA. Well, the administrator will make a decision, and then when you go to court, you're really just having to show that that decision was arbitrary or capricious or without sound basis. In other words, not just that the judge would disagree, but that it was so wrong that it's just shocking. In this case is an example, an unusual example, but it's an example where they find that what the commissioner did was wrong. So let's see why. So the commissioner's determination take three things into consideration. verification requirements of the applicable law, administrative procedure have been met. So in other words, the commissioner's got to say, well, let me make sure we followed our own rules. Number two, the commissioner has got to make sure that the issues that were raised by the taxpayer have actually been considered. And then number three, whether any proposed collection action balances, this is what the IRS does, the need for efficient tax collection with the legitimate concern of the taxpayer that any collection action be no more intrusive than necessary. So if the commissioner has not considered all the relevant factors, normally what you do is you remand it or you send it back down to the lower level to say, do your job the right way. Same thing when we're looking at appellate court decisions, maybe the 11th Circuit decision, where they may say, well, we think the district court judge in Florida or Georgia or Alabama, they did this wrong. So we're sending it back saying, follow our rules, do it again. So here are the three issues that taxpayers raise. So they want their lien released, they want the $800 per month partial pay considered, and they want this exceptional circumstance considered with respect to the offer and compromise that they do want considered. The commissioner did not consider the installment agreement or the offer and compromise and made no mention of exceptional circumstances in the administrative record. So now we're going to look at the lien release and the offer and compromise. So the head of the IRS can compromise any civil or criminal case arising under the Internal Revenue Laws prior to reference to the Department of Justice. So there's all these regulations. We're not going to focus on the details. If you're in this, particularly if you're doing it on your own, you do need to study the actual regulations. But let's talk here about CDP hearings. A taxpayer may offer collection alternatives, and that can include an offer and compromise. And they say, here's this unique question here, and I've never seen this before this case. Whether negotiations with the collections officer constitute a previous administrative proceeding. Well, the significance of that is if it's already been considered, then you have less ability to bring that up again, and we'll see that in just a minute. So here's a section that says, precludes an issue from being raised if the issue was raised and considered at a previous hearing under section 6320 or in any other previous administrative or judicial proceeding. But here's the question. What constitutes a previous administrative proceeding? And it's that the issue was raised and considered. And so the court says, here's the bottom line. It's not a question of whether there was an opportunity to raise your issue about other collection alternatives, but whether they were actually considered. Now, generally, if you have an opportunity to raise an issue with liability, in other words, I really don't owe this $50,000 in tax, and you don't take advantage of that, you lose it. But here, on these alternatives like offer and compromise, installment agreement, the court is saying we have to see if that was actually considered. So unlike the standard of review of an underlying liability, which hinges on the mere prior opportunity to challenge, the standard for whether a collection issue, so again, that's what we're talking about, offer and compromise, installment agreement, can be raised at CDP hearing is whether the issue was actually considered. And so the taxpayers had an opportunity, but they never availed themselves of that opportunity. They only negotiated with the collection officer, did not have a CDP hearing regarding her rejection of the offer and compromise. If you remember, that's because they were trying to get that installment agreement considered. And the court says, well, we can look at under this section 6320, there's a Q&A, and here's the answer. May raise appropriate spousal defenses, challenges to the appropriateness of an NFTL. So that's a notice of federal tax lien filing. And offers of collection alternatives. Again, offer and compromise, installment agreement, that type of thing. And so they say, well, this regulation is explicit. A prior opportunity to dispute the underlying liability precludes its consideration in the next CDP hearing. The regulation is silent as to challenges on the lien and offers of collection alternatives. So bottom line, they say, when you did not consider the offer in compromise, IRS, you abused your discretion. Now, how about the installment agreement? So again, the secretary has the authority to enter into written agreement, make a payment on any tax if the secretary determines it will facilitate full or partial collection. And the commissioner has discretion on what to do. And they review that discretion for an abuse of discretion. They say, we don't conduct an independent review of what would be an acceptable agreement to us. We don't substitute our judgment. We're just saying, did you abuse your discretion? So the commissioner refused to review the installment agreement because they say, we didn't get any financial information. Well, the taxpayer says, I did give you financial information. Go look at that Form 433A. I know there's so many form numbers and all that. Just if you're going to be going through this with the IRS, you've got to learn these form numbers unless somebody is helping you with this. And even if you hire somebody, I'd suggest you still need to know what's going on to make sure you're getting good representation. So they say, look, it's not an abuse of discretion for the appeals officer to reject a collection alternative when the taxpayer does not provide the financial information. Well, that makes sense. If you take it in the context of you're facing foreclosure, you ask the mortgage company, hey, take into account my financial situation, give me a break here. And they go, okay, give us your financial information. You say, I will not do that. It's kind of obvious a mortgage company can go, okay, then we're not going to consider you for this. Same thing in the tax world. So the question is whether their Form 433A and accompanying documents satisfied that request. And they say, well, look, if the stuff is out of date, it's okay to ask for an update. And if you refuse to give the updated information, then you can be rejected, and that's not an abuse of discretion. So I'm going to the IRS and I give them a bunch of financial information in 2017. Now it's 2020. And they say, hey, John, your information's 3 years old. Give us new information. I go, I will not. Well, then they can reject it, and that's fine. But here, the record does not indicate Commissioner ever considered the financial information or looked at the age of the information or whether changes had occurred. So again, I'll relate this to dealing with your mortgage company. Your mortgage company says, give us 3 months of bank statements. So you give it to them. Now, if 6 months goes by, they can legitimately ask you to update those. But let's say they never do. And they say, give us 3 months bank statements. You go, I already did. There they are. Now, if the mortgage company just says, well, you never gave them to us, then they can't rely later on and say, well, actually those were out of date. It's like, no, you have to look at them to determine they're out of date. It's the same thing here. The stated reason for the rejection was that the taxpayers did not provide the financial information, but they did. Commissioner abused his discretion. Now, this economic hardship. So they did not use these words. These are sort of the magic words, okay? Effective tax administration. That's where you say, look, I've got the ability to pay either income or assets, but I'm asking you to give me a pass on this. So that's my 90-year-old guy who's disabled and's got his house perfectly set up. It's that type of situation. So here the taxpayers are arguing collection of full liability caused an economic hardship. And if we had to pay the liability in full, that would cause an economic hardship. No evidence that the commissioner ever considered that. Never considered the economic hardship, whether effective tax administration was appropriate. And it says, while the commissioner noted the economic hardship argument in the administrative record notice of determination, he never evaluated that claim. So he says, yeah, I know they raised that, but I didn't look at it. Well, that's a problem. It's an abuse of discretion for the commissioner to neglect to consider all the issues raised by a taxpayer. They raised the issue, and he abused it. So this is just saying same thing. And they say, we remand this case to the appeals office for further consideration consistent with this opinion. So in other words, what they're saying is, you better consider them for the offer in compromise. You better consider them for the installment agreement. And you better consider this effective tax administration or these unique circumstances that make it such that perhaps the taxpayer should be excused from paying anything. You've got to look at it. Now, the tax court's not saying you have to give them an offer in compromise. You have to give them an installment agreement. You have to declare that this is effective tax administration. They don't owe anything. They're not saying that, but they're saying you have to look at it in a fair and proper manner. And so I know this got a little tedious in there with, was there a prior hearing and all that, but it just shows you that there oftentimes are issues that are brand new. And so we have to really do some creative thinking here to show why we are right. And it also shows that the power of keeping your documents. So I don't care if you're dealing with your mortgage company, credit bureau, who you're dealing with, keep your documents, okay? You send something to the IRS, keep an exact copy of what you sent so you can prove that later. So hope that that's helpful. If you're dealing with tax issues and you want to chat with me, I'm happy to do that. Again, my name is John Watts. It's 205-879-2447, or you can contact us through our main website, alabamaconsumer.com. And so I practice law in the state of Alabama, and lawyers will get me involved in other states as well. But if we're dealing with the IRS, really that's a nationwide practice because we're not going into a particular state court or even federal court in a state. We're going before this federal agency. And so wherever you are, I'm happy to talk with you. And if I think I can be of help to you, I will, or point you in the right direction. So 205-879-2447 or alabamaconsumer.com. Okay, guys, thanks for watching us, and I will get you in the next one. Bye-bye.